afternoon. I am so pleased and honored to be here. I want to extend a huge thanks to Judge Bigler, to all the judges of the Creek Nation, and to the staff, the court staff that make this work in such a beautiful way each year. It's wonderful to be on this beautiful land and this wonderful, place. I feel very, very honored and very comfortable here. This is my favorite conference by far. I was here in 2014, and I learned so much. I love the difference of the traditional jurisprudence and then federal Indian law and what's going on. And I think that this is a very important format that many indigenous nations ought to follow, and in terms of including the international perspectives too. I'm very honored to be with wonderful colleagues who are doing this work. And Kristen, thank you so much for joining me on this portion of the program to give any updates that you have from the important work that you do. So, with your permission, please allow me to serve as a sort of bridge between the amazing discussion that we had this morning. The presentations were phenomenal, and you wouldn't get that information anywhere else. And then we're going to transition into some very important doctrinal work in federal Indian law. So my presentation really is going to focus on the construction of cultural heritage and what that looks like as a matter of tribal law, domestic U.S. law, and international law, knowing that we have to operate in each of those spheres. And Alexia, thank you for the slide about the items that are held in Sweden. On behalf of Yaqui people, I am Yoemit from Arizona. And that is an important thing to know, that there were many, many collections that were taken overseas. So all of the federally recognized tribes here have very important objects of cultural patrimony and sacred objects, and in some cases even ancestral remains that are located overseas. And our domestic law doesn't reach that. But the tribal law claims responsibility for all of those things. So I think we very much have to engage that discussion. So I don't have a fancy PowerPoint because I don't have a student RA this year, and I don't know how to do PowerPoint, so I'm just going to admit that. But these are the things that I want to talk about. I want to start by talking about what Judge Bigler referred to in this excellent, excellent article, and I read that and really think it's amazing, and everybody ought to read that article. But he talks about traditional jurisprudence, and so I want to ground with that. And then move on to talk about cultural heritage. And there is obviously an important provision of the UN Declaration, Article 31, and Jason's going to be pulling that up so that we can talk about that. And the translation into Greek is definitely worth engaging in Q&A if we have time to. And the third and fourth things I want to talk about are the fact that cultural heritage is mainly aligned with the world of tangible items, material items, and that's where the construction of cultural property comes in. In fact, the value is intangible, and those categories, as Yoni Spencer talked about earlier, are inseparable. The world of the intangible is inseparable with the world of the tangible. So that is the challenge of traditional jurisprudence in the world that we live in today. And I'm going to conclude by talking about some new work that I'm doing on data sovereignty, and this would be digital data, which is actually used in ways that even I had not considered when I started doing the research. But these are issues that indigenous peoples worldwide are concerned about in the sense of indigenous data sovereignty, and certainly federally recognized tribes in this country probably have the strongest argument for claiming sovereignty over their data. So I will conclude with that. So in terms of the first item, this idea of traditional jurisprudence, in Judge Bigler's article, he says that has to be the foundation of current international indigenous rights efforts regarding sacred sites, artifacts, religious practices, and culture. And I strongly agree with that statement in every sense. So that grounds this presentation. He also, drawing on the work of other scholars, talks about law in a way that I think is very helpful to our discussion. So he talks about law as, number one, rules. Rules that channel and control behavior in society. And I think that we're used to thinking about that in terms of positive law, right? We look at the USC, we're looking for a provision that says we can do this or can't do that or whatever the case may be. And sometimes we think that positive law is the law and it must be enforceable. And that's where many of my colleagues, actually my senior colleagues, when I was at ASU, they didn't want any mention of international human rights in relationship to Indigenous peoples' issues because they told me it's not enforceable. Just look at the code, look at the US code, look at precedents, don't look at international human rights law. But as I got to know more about the field, I learned about the second category that you talk about, which is customary law. Right? That which you do over long periods of time becomes the law and becomes enforceable as a matter of law in the international law domain. That is also the case, I think, in many tribal nations. These are unwritten, as Mr. Spencer talked about this morning, but they are the law. And the third sense of the law is practices. So, practices that facilitate the resolution of conflict. So we have customary law on the one hand that tells us what to do, but in cases of conflict, that's where there's a breach of the relationship that can actually cause further harm. And domestic violence cases would be one that tribal court practitioners see. Similarly, family disputes over probate, who gets this, who gets that. Those can divide families, they can divide clans, they can cause all sorts of disharmony in a people. And so looking at the ways that we heal conflict, both internally, are important. But also, as Alexi noted earlier, that's the language of reconciliation, reparations for past harms and sometimes continuing harms that governments commit against Indigenous peoples. And we have those examples with the boarding schools, with the appropriation of sacred items by agents and others. That's why we have repatriation laws, because of those practices. So in all three of those senses, the law is performing important work. And I think that that's the language that I want to use in this presentation. The last insight, and there are many from Judge Bigler's article, but there's one last one that I thought was of essential importance. And he distinguishes between the survival of certain cultural practices and the sustainability of those practices. They're sustainable when they are lived, when there's a community with shared knowledge, where this is an ongoing daily practice, the life of the community. In the sense of native languages, as he points out in his article, a lot of times we're just talking about the survival of a language, the basic survival, and not the fact that there's a pool of speakers who are comfortable and conversant in speaking the language fluently. In Arizona, where I am from, the Navajo Nation is the largest tribe, and of course they sit on the four corners, so they are not part of any state, but they intersect with the states. And they have a enrolled membership of over 300 members. In 1969, 95% of Navajo children who entered school were fluent language speakers. In 1993, the number was 52%. In 2009, which is the last statistic that I had information for, 30% of the children were fluent language speakers. Now, why is that? There are multiple reasons, but state policy affected that greatly. Arizona enacted English-only legislation in the late 90s that banned immersion programs. A lot of the schools that serve Navajo children are state schools, and there had to be a long political fight about native language speakers credentialing. That took years before there was a system. Why didn't federal law protect? There's a Native American Languages Act. That statute, which is in 25 U.S.C., is a lot like the American Indian Religious Freedom Act. It's a statement that the United States wants to protect and preserve Native languages, just like it wants to protect and preserve Native religions. But they're not enforceable in court. So there was no way to sue the state of Arizona for the impact of its policy on the Navajo Nation or any other affected tribe. This is all politics. And that statute is still on the Arizona books. So the way to think about that, and encouraged by Judge Bigler's article, I think, was the approach that Wallace Coffey and I took in our article, which was a joint authorship when we were both members of the Native American Rights Fund Board of Directors. And we were very angry with the effort of the United States Supreme Court to limit tribal sovereignty continuously by reference to the federal Indian law political sovereignty doctrine. So yes, you have inherent sovereignty until Congress says you don't, or until we think you shouldn't. Judicial plenary power. That seemed offensive. How could inherent sovereignty be up to the United States Supreme Court? And in fact, as we talked to our colleagues and others throughout Indian country, we realized that cultural sovereignty was the source of political sovereignty. And in that sense, indigenous nations here and elsewhere, I would argue, are completely unlike the United States. The United States was born, created in 1776. When was the Creek Nation created? Time immemorial, the lands, time immemorial, the histories from time immemorial. That is a very important and distinctive status grounded in the unique histories, culture, language, traditions of all of these indigenous nations. So that's the importance of cultural sovereignty, and you can only understand it by looking within, which is the importance of indigenous knowledge, which is the importance of indigenous languages, right? So it all is interrelated. And there is no way for any external source like the US Supreme Court to even understand that unless the indigenous nation creates a carefully articulated pathway. And I think that that's what Judge Bigler is suggesting in his article, which is very good. And by the Creek Nation turning the Declaration into a document of Creek law and Creek language, that is exactly what we're talking about. It is from within. And I really appreciated how Rebecca Barnett talked about the strength of the words, too. These are not English words. These are the words of the Muskogee Creek people. Very, very important. Okay, so cultural heritage, second topic. What is it? Who has rights to cultural heritage? We could talk about that at length, but there's always a corollary to that, which is who has the responsibility to protect cultural heritage, right? You have a right, you have a responsibility. Where are they located? If you say cultural heritage is a resource, and I would want to question that, but let's just say that we agree that it's a resource, then the United Nations and UNESCO in particular tell us that the resource belongs to all mankind. That's who it belongs to. Everybody has a right to cultural heritage, and it is a shared responsibility of every nation state to protect cultural heritage. That is cultural internationalism. If you think that the nation states themselves, the sovereign governments, the United States, Greece, England, if you think that the nation states hold the rights to their cultural heritage, then each sovereign has the right to control its own cultural heritage, right? Nobody else can tell you what to do with it. When there's a transition in governments, some forms of cultural heritage are going to disappear, but the nation state is going to decide about that. And I see a level of that discourse happening in this country over the embattled Civil War statutes and things. So people are saying, well, whose cultural heritage is that? Whose history is that? Does it get to disappear? Should it disappear? What does it stand for today? So that is cultural nationalism. And the treaty, the 1970 treaty that governs the illicit import and export of cultural property among nations is built on that model. Each nation state defines its own cultural property and says you can't take this out of the borders, like if you tried to steal the United States Declaration of Independence or something and take it to Germany, the nation state would control that under domestic law. Where do indigenous peoples fit within that structure? And that is a contested feature of international law right now because we're talking about sub-national groups. And a lot of times ethnic, minority, religious groups all get lumped together and indigenous peoples get lumped into that. And that is the reason why the UN Declaration on the Rights of Indigenous Peoples is very important because it distinctly says the location of those political rights internationally, the right of self-determination is grounded in the status of a people. And a people could be the same as a federally recognized tribe, but it's not limited to that, right? There are trans-border peoples. For Yaqui people, Yuami people, there's more in Mexico than in the United States. Tona'atam on the border, more in Mexico than in the United States. Those are trans-border peoples. What do we do about their rights to cultural heritage? So, in this sense, I want to sort of move on to a discussion of what U.S. domestic law says, because for the tribes that are located in the United States, U.S. domestic law is determinative. But then juxtapose that against the sort of international regime. And I'm going to, I guess, in a sense, get there from the standpoint of a current issue. So does anybody remember the sales in Europe in the auction houses? Those are still going on, but there was a very well-publicized one in 2014, which was in the Paris auction house. Had a lot of objects that belonged to Southwest tribes. They were sacred objects and objects of cultural patrimony. The Hopi went to get their objects, and France said no. And the Hopi said, well, our Constitution says that's our cultural property. Why no? Because you're not a nation state, because the United States, which is the nation state, didn't enact any law protecting the export or import of indigenous property as cultural property, so there's no retention ordinance. And because your argument, and this was to the Hopi specifically, was that their medicine pieces were alive. They weren't inert, they weren't active, they were alive. And they said, no, as a matter of law, those objects are not alive. They don't have personhood. So how to get that back? There is a Safeguarding of Cultural Property Act, Indigenous Safeguarding of the STOP Act it's called, that still has not passed Congress. But if it passed in Congress, what it would do is have the United States say, any object illegally exported under the domestic laws that I'm going to talk about in a minute is protected under that 1970 treaty as U.S. cultural patrimony, and our policy is to repatriate it to indigenous nations. Now, why hasn't it passed? So the reason it hasn't passed is the other part of this. People think of those items as art. They're sold at art auctions. So the idea that something is art and the idea that something is sacred object of cultural patrimony, there's a disharmony there. And the understanding really comes from tribal law. So in the United States, the statutes that govern cultural heritage, and I know that this is going to be a repeat for many of you in this room, but others may not have worked in this area. So that would be the Antiquities Act of 1906, the Archaeological Resources Protection Act of 1979, the National Historic Preservation Act of 1966. Those are the big baseline cultural heritage statutes in the United States. The Native American Graves Protection and Repatriation Act of 1990 is the only one of those statutes that was designed to effectuate the U.S. government's trust responsibility to Native people. And its policy is to serve the human rights of Native people. And that's in the legislative history. It is a human rights statute. So it's very important to see how different these are. And this is an area of law that I have worked on for many, many years, and I've seen a tremendous amount of growth in these statutes. But the Antiquities Act is basically unenforceable with respect to sacred items and objects of cultural patrimony. It basically says anything, ancestral human remains or any of those items found on federal land is federal property. So under the Antiquities Act, ancestral human remains on federal land are specifically federal property. That's very troubling. The other provision of the Antiquities Act is to designate, the president can designate national monuments. So anybody familiar with Bears Ears National Monument, that is in litigation right now because the current president disagrees with President Obama's statement that that is worthy of being a monument. And it is worthy because it is the living ancestral culture of all of those affiliated natives, and they have an indigenous knowledge that goes with that. That's right in the proclamation. So the intangible value to the current people is really the purpose of that national monument, in addition to the historic importance to the region as a whole. So that is in litigation right now, because the current administration doesn't agree with that. But if that is cultural heritage, the intentional destruction of cultural heritage as of 2015 in international law is a crime under international law. The Archaeological Resources Protection Act says any archaeological resource of 100 years old or more that is found on federal or tribal land is protected by federal law. And so the 100 years or more does not protect any items that are made after that, right, by indigenous peoples that are taken. So it's a very limited statute. But it is an important statute, and it was modified by NAGPRA to basically call for a consultation about tribal property and remains. And the National Historic Preservation Act gives us a process, and it has been amended in many important ways, but one of the important ways was to actually call for the designation of a traditional cultural property, which is a natural site that's sacred to a tribe, can be protected under the NHPA. It doesn't have to be a man-made building, for example, the way that other historic resources are. So that has been used to protect sacred sites, but it is very much procedural, and the Havasupai are dealing with that right now because they have a very sacred mountain that's just south of the border of the Grand Canyon. So it's not actually on federal land, but it's a highly sacred site. And there's a uranium mine there that's been dormant for many years.
but just started up again recently. And they've actually said that you don't even have to consult with the tribe because that permit was issued before it was a TCP, before there even was a TCP amendment, and they're just relying on the former permit authority. So that one also was in litigation, but you know, these are procedural statutes. So NAGPRA was the one that did the primary work of the trust responsibility. And that statute obviously covers ancestral remains, it covers funerary objects, objects of cultural patrimony, which are defined under tribal law as inalienable from the tribe. You can't alienate it. And sacred objects, which are objects that are used by current practitioners for traditional religions. So those are the areas that are covered. And it is that latter reference to those two categories that really informs cultural property. So if you think about the term cultural property, what is property? Under Western property systems, chattels, for example, those are objects, right? Material objects that can be owned by a person, and the right of ownership is the right to include others or to exclude others. That's what ownership means. If we go back to what Yoni Spencer talked about this morning, he said these things can't be owned. That paradigm doesn't even match up to it. It's the idea that you have the right to continue a cultural practice in relationship. And that is what actually governs the idea of the cultural importance. So there are a number of cases where objects were taken under various means from tribes and sold to non-Indians as art. And under NAGPRA, the trafficking in any of those objects is a federal crime. So the Corot case, that was a case of Navajo medicine bundles that belonged to a traditional healer. He passed away. His widow had these items, and a non-Indian who had been in the community for a while said, you know, do you have any use for them? She said, well, I personally don't know how to do this, but I would want somebody else to have it who could use it. He says, well, I know a young Navajo singer in Utah, and if you sell it to me, I'll make sure that he gets it. So there was a transaction, but instead of that, he actually sold it to an art collector for 7 times the amount that he had paid her, and the art collector, quote unquote, was a federal agent. So that fell right within the crime, but it really had to, the case turned on the tribal practitioners. So he had a tribal practitioner say, look, if a widow owns it, it belonged to the healer, it did not belong to the tribe, she had the right to do whatever she wanted with it. And the witnesses for the tribe said, no, those medicine bundles are part of the Navajo cultural healing ceremonies. The tradition is to give them to another person, that intergenerational transmission, not to alienate them outside the tribe. So it really was the cultural patrimony part of that protected it under the statute. And so he was convicted. And there's a famous tribal court opinion about items that belonged in the Northwest to the Tlingit people up there. And again, somebody came in, wanted to buy from a tribal member. The tribal member sold the items, claiming that they had the right to do that, but they didn't. And the tribe had actually enacted a cultural patrimony retention ordinance as a matter of tribal law that said these items are tribal and they cannot be alienated. And it turned out the traditional penalty for doing that was actually the death penalty, because those were so important to the tribe. So that case, again, resulted in the objects being returned to the tribe. But the tribal law was key to the understanding of the items and those ancestral associations. So as I bring this to a close, then let me focus on the world of the intangible, which there's a big discussion right now in international circles about traditional knowledge. The World Intellectual Property Organization is engaging in a series of discussions that have been going on for years about the rights to traditional knowledge, genetic resources, and traditional cultural expressions, all of which have a technical meaning, but all of which obviously are parts of indigenous cultural heritage. And the article there, a round of applause in case of video so much. Yes, there it is. So if you read the text of that, right, indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions. All of that is in the WIPO treaty process right now. And I'm just focused on the first clause of that now. But we don't even know what the cultural heritage means without the indigenous knowledge, right? That's what actually says the significance. So the way that non-native people look at this in WIPO and in other proceedings is they look at the way that knowledge is associated with things that people care about. So is it associated with health practices as medicine? Can you patent it? Is it associated with climate adaptation as traditional ecological knowledge, in which case it can give us an important sustainability practice? All of those put the knowledge into various categories, and that categories tell us what we can do with the knowledge. Can you own the knowledge? WIPO doesn't think you can. WIPO says knowledge is shared, and if it's shared widely, you can forget about ownership. If you keep it close, like a trade secret, then you can own it. So the categories are very important to the protection of that. Reading on, there is the reference to manifestations of science, technologies, including human and genetic resources, seeds, medicines, knowledge, properties, flora and fauna. The list is very broad and inclusive, which is good, but it also requires delineation according to indigenous jurisprudence. And that is a conversation I hope, Judge McLeary, that you'll weigh in about the translation of it. Because when I was doing the work on NAGPRA, there's a category of NAGPRA that refers to culturally unidentifiable human remains. And they can be culturally unidentifiable for a variety of reasons, but one category in particular was ancient remains that couldn't be culturally affiliated to any one contemporary federally recognized tribe. There was a site in Chaco that was excavated, Chaco Canyon. It was excavated in 1896. And the remains were taken to the Natural History Museum. A recent study published the DNA analysis on those ancient remains and said, our IRB said we didn't even have to have a consultation with any federally recognized tribe because that was so distant they couldn't be culturally affiliated. And yet the conclusions that were drawn, and by the way, the burials that were excavated spanned over 300 years. And they are still in that museum. They are not being repatriated. That is the property of the federal government. The data that is taken from ancient remains is put into libraries, archives, as DNA data. And this is globally. There are big global databases of this. And the associations of the data are made to genomic information from current populations. And this is, again, it's worldwide. When I did this work, and we actually, the colleagues that I worked with held groups where we invited cultural leaders from every tribe to participate and talk about their beliefs about what should happen to the remains. There was not one at that time, and that was in 1998. There was not one that agreed that you could do destructive DNA testing and moreover link it up to human populations, origins, research. That is exactly what's happening right now. Some of it is happening by consent. The contested cases, Kennewick case, the Spirit Cave case in Nevada, those remains were 10,000 years or older and claimed by current tribes, but they wouldn't give them back until the tribes did the DNA testing. And in both cases, it showed under the current DNA evidence that he, in both cases, was their ancestor. So do we need that? What is going to happen to that information? That's data sovereignty. There aren't any rules about this right now, but it fits within that slide. So this is an important area, and I'm sorry if I over-exceeded my time, and I really want to welcome my wonderful colleague, Kristen Carpenter. Please come in. Anything that I've left out, you can clean up. Thank you so much.
Good afternoon. Thanks, Rebecca. I think this invitation to follow Rebecca Sosi is really punishment from Judge Bigler for anything bad I've ever done in my life, because nobody ever wants to speak after Rebecca Sosi. She's the most powerful, inspirational, gracious, joyous presence. And every time she speaks, I'm reminded why I do what I do. As academics, sometimes we feel far away from the communities that we try to serve. But Rebecca really has an ability to bring it all back to the work that motivates us and you all on a daily basis. So just a couple of comments. First of all, thank you, Rebecca. That was beautifully said. Second, thanks to Judge Bigler for this amazing event. And I don't want to spend a lot of time doing thank yous, except to say that I hope and I imagine that all of you in the audience realize what an incredible treasure you have with Judge Bigler on your district court. And I do federal Indian law around the country and have for many, many years, and I now do a lot of this international human rights work. But what you all have going on here is some of the most amazing work happening in Indigenous peoples law that I've seen anywhere. I mean, you're really thinking about customary law, you're thinking about language, you're thinking about culture in ways that are so much deeper and more sophisticated than what I have observed in other places. And I guess one of the things that I'd like to say along those lines, again with the benefit of some comparative looks, and I've been to, a dozen countries in the past year or two working with Indigenous peoples, and it's actually given me a little bit of appreciation for the opportunities we have here in the United States. For example, Alexia said in Russia, and this is true of most of the places we go, where Indigenous people don't have jurisdiction over their own lands, never mind tribal court systems, to use their own laws and values to adjudicate disputes and regulate matters like the environment or the economy and so on within their borders. And I think the work that Judge Bigler has done on the district court of bringing you all together is an incredible example of the power of that jurisdiction to really create and inhabit tribal worldviews and realities in a way that has that sustainability, to use your word, Rebecca, and is meaningful on a cultural sovereignty basis as well. Just two concluding points, and I know we don't have a lot of time, but you've heard now a lot about tribal law, a lot about international law and federal Indian law. And one just a sort of way I think about all of this is that the relevance of international human rights law to American Indians in the U.S. is through one of two paths. We have the opportunity to implement in the United States and in our own tribal communities the principles of the Declaration on the Rights of Indigenous Peoples. And as you probably heard, this document was adopted by the UN General Assembly in 2007, and it contains all these provisions that have a lot of power and potential to decolonize federal Indian law, to support tribal worldviews and customs. And our job on the expert mechanism, one of our jobs is to help Indigenous peoples and national governments implement the declaration domestically, meaning in their own countries, in their own tribes, etc. And when I heard Rebecca Bennett speak about the translation of the declaration, and I've heard about the tribal court processes, I mean, that's exactly what you're doing, is implementing the declaration in your own community to the extent that it's relevant to legal reform and to goals and aspirations of the community. The other opportunity to participate in international human rights forums is literally by going to those forums, whether it's in Geneva or New York, and participating in the meetings. And some of the, again, acronyms you've heard, for example, UNESCO, the UN Education, Science, and Cultural Organization, has offices that are entrusted with things like repatriation or language. WIPO, as Rebecca was just mentioning, has to do with traditional knowledge and genetic resources. We have all of these indigenous mechanisms. And so, sort of as contrasted with bringing international law into tribal communities, you as advocates or members of tribes can go to international forums and participate if you feel like they are relevant to your work. And so, for example, tribes that have cultural property in a foreign museum, it's directly and obviously relevant to their needs to go engage in international processes to get that item back. And there are other issues like having the dignity and respect of your national government or other national governments, as well as some of the things that we've talked about with respect to security and trade and various other immigration, various other international issues that tribes might deal with. In closing, so I do serve as the North American member of the Expert Mechanism on the Rights of Indigenous Peoples. It's a very long name. And one of the things that's occurred to me is that many tribal communities don't have a lot of access to the UN. So if you're interested in any of this stuff, whether it's implementation or participation, I'm your girl for the next 3 years. I mean, it is my job to be accessible to all of you. I feel particular affinity with Oklahoma and with the Muskogees and the Cherokees. My family's from Muskogee and Tonopah and Porter and so on. And I've been traveling around the country going to different tribes, but certainly the issues that are meaningful to people here are ones that are near and dear to my heart. And I didn't mean to leave out the other Oklahoma tribes. Those are just the ones where I have relatives. But in any event, thank you very much, and I look forward to the rest of the afternoon.